Meal of the day.
This one,
Not black. Ngerizanela nasitsha lo le premier so. Alakho.
How are you? Good. Is the recording better? I think last time we were in the other building there were some difficulties because we kept speaking from where we were standing.
yeah, you mean things of everybody.
Yeah.
Well, the recording is just a problem with
Jeez.
yeah.
For the Wi-Fi.
Yeah. But the other one that they give it to us, I don't know if we use
I already see my that like you that time and it's that was too much.
How are you? Fine, thanks. No, it's extremely hot. And here we are all in our suits.
Yes. Hello? Yeah.
Not
Hey, Brian. Yeah. Okay, wala ko yung tako. Okay, now, on out of Brahmana, you know, if you have response and do that, like, make more permission. That one.
No, aí o senhor tá
Thank you, Ms. O'Brien.
As it pleases the Commission. Chairperson and co-commissioners, I appear on behalf of the first respondents in support of the application by the applicants. The first respondents for the context of this commission are the former residents of the Usindiso building who were directly on the receiving end of the effects of the fire at the Usindiso building and who have also been at the receiving end of treatment and experiences that are negative from Operation Dudula. The basis for the support of the applicant's application for recusal of Commissioner Makubela is because the residents reasonably hold an apprehension of bias against Commissioner Makubela on the basis of his published tweets and statements relating to Operation Dudula, his support thereof, and the relating sentiments. Chairperson, the first respondent will address this commission in the following sequence. First, to have a discussion on the main features of the commission as it directly relates to the interests and outcomes of the residents and their experiences in the Usindiso building fire, relevant background. Thirdly, we will provide details as to Operation Dudula and related organizations. Fourth, we will have an analysis of Commissioner Makubela's tweets in the context of Operation Dudula and related organizations. Fifth, we will explain, and the Commission must bear with us if repetition has effect from what we say with Mr. Brickhill's statement. It is for the purpose of advancing the interests of the first respondents in their support of this recusal. And sixth, we will highlight the facts on which the apprehension of bias is based that warrant the recusal of Commissioner Makubela. Chairperson, the respondents whose testimonies will be heard as part of this larger process of the Commission comprises of individuals who are both foreign nationals and South Africans. The foreign nationals in particular have experienced xenophobic violence, intimidation and trauma at the hands of members of Operation Dudula directly. Their experiences are canvassed in the submitted supporting affidavits, and I will discuss and draw specific attention to the various events where Operation Dudula has been a key driving force of violence and or intimidation and or harassment of the members of the first respondent. It is necessary to state that the period of many years that Commissioner Makubela published tweets, liked tweets, engaged in other publications on Twitter relating to Operation Dudula and or the Put South Africans First movement have been cause for concern for the residents. In explaining the relevant background, I will go through both the makeup of the residents. At present, and I'm subject to correction as to the number of statements, but at the time of preparing these papers, 340 residents had been interviewed and their statements had been taken. Of these, there were 153 South Africans and 187 foreign nationals who had been affected by the Usindiso fire. While this is not a complete list, we do surmise that more than 187 foreign nationals were affected by the fire, either through death, injury, resulting homelessness, and continuing effects of Operation Dudula. The Commission's terms of reference require the Commission to make findings as to who must shoulder the responsibility or liability for the state of affairs, death and injuries. The Commission must also recommend appropriate steps that must be taken and by whom, and any other recommendation that may appropriately address any relevant matter arising in relation to the scope of the inquiry. The first respondent views this as central to why this recusal application is being supported. However, whatever the motivations for bringing it, the support is because the Commission, being an independent and impartial body that is expected to undertake its findings and work without fear, favor, or prejudice, must also be expected to have a level of impartiality not just for the residents, but for the public in general. Considering that the majority of residents who have been consulted so far, and likely if more residents come forward to join the group of the first respondents, that there will be more foreign nationals. It is critical that this Commission is clear of any anti-foreign elements, particularly as its findings may implicate, alternatively, residents and who are foreign nationals and or South Africans in some wrongdoing, or make findings as to the circumstances of those parties, where the larger group is a mix of South Africans and foreign nationals. The recommendations may also negatively or positively affect some residents. We do not seek to preempt the outcomes or the findings of this Commission, but we do surmise that there will be significant impact in the way that these findings will affect both the resolving of the trauma, in unpacking how, when, and why the fire may have occurred, if that is explored by the Commission to such an end as a finding can be made, or if recommendations are made as to what to do in addressing what has happened to the residents. In light of the above, the presence of Commissioner Makabela may undermine the credibility of this Commission's work, which is owed to a reasonable apprehension of bias against him. Whether or not that affects the machinations of this Commission, the apprehension is enough, and that is, in case law, the principle. It's not whether there will be a practical effect of perceived bias, it's whether there is an apprehension. In what was revealed and set out in the founding affidavit of this application by the applicant, it was revealed to the first respondent that Commissioner Makabela was, for a significant period of time, an active supporter of Operation Dudula and Put South African First group. It is trite that these are anti-foreign groups. They have publicly celebrated the fact that foreign nationals who were residents of the Usindiso building had been affected by the fire. This is canvassed in the supporting affidavits, where many residents record that on the morning following the fire, where they were still in the aftermath of the horror that had ensued, members of Operation Dudula had transported themselves to taunt and celebrate the tragedy. If allowed to continue in his role as a commissioner, there may be an effect on the cooperation of residents, which may cripple the Commission's ability to get to the bottom of the issues that it seeks to seek clarity on. The residents are homeless or in very difficult circumstances. Their level of trust in this process is central. In terms of the background, while it was canvassed by the applicant, it does bear repetition that between 2017 and 2022, Commissioner Makabela posted or reposted content that was almost exclusively related to foreign nationals, often criticizing government for not addressing issues he deemed to be associated with foreign nationals, with some direct statements to members of the ANC. These may be found at the founding affidavit at paragraph 14.3 and its subparagraphs, read with the first respondent's supplementary affidavit at page 3, paragraph 7. It's submitted that the analysis, which will come later in my submissions, reflect a level of focus by Commissioner Makabela that cannot be ignored. The content found in the liked tweets portion of the account reflects a similar fixed area of interaction. Those tweets often reference hashtags such as Put South Africans First, and content published by individuals who are known to espouse xenophobic rhetoric such as Nhlanhla Lux Dlamini and Herman Mashaba. It is unknown at this stage, and no submissions or statements have been put forth by Commissioner Makabela to challenge any of the averments made by the first respondent and the applicants as to his views. But it is unknown to what extent Commissioner Makabela is involved in Operation Dudula offline, if at all. However, his account bearing his name, as was canvassed earlier, interacted with various posts that denigrated foreign nationals and expressed approval of sentiments that supported the rhetoric of individuals such as Herman Mashaba and Nhlanhla Dlamini. The first respondent has a genuine concern and a reasonable apprehension of bias, and if this application is unsuccessful, there is a reasonable perception that it may arise that the neutrality, impartiality, and integrity of this commission may come into question. In respect of Operation Dudula and related organizations, it does bear mentioning the philosophies that underwrite such organizations and what they publicly put out for support or rallying action. Xenophobia and anti-immigrant extremism are philosophies that perpetuate the sentiment that foreign nationals within a country, often foreign nationals from developing countries who are migrants or asylum seekers, are responsible for a variety of social ills. These sentiments are often used to radicalize individuals through notions of extreme nationalism. Often groups that espouse the xenophobic rhetoric, they prey on anxieties suffered by citizens of that country, often using economic insecurity, crime, and unemployment as the force to support this radicalization. It's trite from the papers that many of these concerns are reflected in the tweets posted by Commissioner Makubela, which relate to crime, relates to unemployment, and relates to financial insecurities that may have motivated some of the xenophobic rhetoric that had been pushed by Operation Dudula. With Operation Dudula specifically, as stated earlier, but it does bear repetition, it's founded on xenophobic rhetoric underwritten by a shared perception that the cause of issues faced by South Africans are as a direct result of the presence of foreign nationals. It was founded in June 2021 and has since been responsible for many instances of attacks and or the intimidation of foreign nationals within South Africa in the form of raids, mob violence, and anti-immigrant protests. I pause now simply to alert the Commission that since the recusal application, and the Commission is aware because they were cited in the papers, there had been an urgent application that cited Operation Dudula for its involvement in the intimidation and harassment of residents in a larger dispute that related to the housing and security of the residents while awaiting the Commission continuing. Operation Dudula is aware that there is a large group of foreign nationals who are at risk and have been on sworn statements involved in the harassment and further intimidation beyond what is set out in these papers regarding the events immediately following the fire and intimidation as it had occurred prior to the fire. Operation Dudula is not a fixed organization in the traditional sense. It is an amorphous group. It overlaps with other ultranationalistic, xenophobic, or Afrophobic movements, and that includes the Put South Africa First campaign. It is a highly active presence on social media, and I must mention that social media appears to be the medium for mobilizing members of Operation Dudula. There is no set meeting place, but they use the marketplace of the internet to disseminate ideas, to spread ideas, and to garner support. Their members answer to calls to action. They are mobilized using Twitter. Supporters often respond to the clarion call of Operation Dudula with little regard for rule of law, and they engage in campaigns that incite or inflict violence against their chosen antagonists, those antagonists being foreign nationals from African countries who now reside within South Africa. Plainly, Operation Dudula does not merely hold a generalized far-right political view that could be attached to any number of issues, as with most political parties across the political spectrum. Instead, it has a singular focus that utilizes violence, hate speech, and action that targets foreign nationals, and the members mobilize accordingly. It's reasonable to assume that a member and a supporter of Operation Dudula shares at least some of the views within the specific area of focus to the point of possibly being radicalized to the movement beyond what is, I would say, a rational interest or a normal level of interest. This is a group that has very clear goals, and ambitions. It's not too far-fetched or remote to attach an apprehension to Operation Dudula, where it relates to the residents of the Usindiso building. And this is evidenced in the supporting affidavits, where members of Operation Dudula had, on more than one occasion, conducted raids of the Usindiso building prior to the fire. They issued warnings. They spent a lot of time and energy targeting the Usindiso building. So it's not a remote notion that Operation Dudula has a level of interest in the foreign nationals who resided within the Usindiso building. And in fact, as I had stated earlier, that level of interest in intimidation and harassment did continue on. In a further analysis of Commissioner Makubela's Twitter activities, the first respondent notes that Commissioner Makubela was appointed as an additional member of the Commission to assist the chairperson of the Commission to conduct the inquiry in Chairperson, your work in preparing the report of the Commission. This appointment was made on 13 September 2023, which is not too long ago in the larger scale of things. Whilst Commissioner Makubela provides a function on the Commission in assisting the chair, and we can only surmise that is due to his legal background and his experience with various state-owned entities, those aspects do not lend the same cloak of impartiality that is presumed to be applied to judicial officers such as yourself, Madam Chairperson. The perception and practice of neutrality in respect to the very issue that cut to the heart of this Commission are intrinsically affected by the inferences gleaned from Commissioner Makubela's social media account. And those inferences are not slight. They are stated strongly. They are stated unequivocally. They are stated passionately. The support of this application is not brought lightly. It is brought on a real, well-founded apprehension. And that apprehension is based on the following. In the samples provided to this Commission of the Twitter account of Commissioner Makubela, much of the content is focused on the issues on foreign nationals and the inference of related crime. A closer analysis reveals that there had been high levels of engagement, almost exclusively to anti-immigrant sentiment and or expressly Operation Dudula. It appears to be to the point that the account has a focus on Operation Dudula to the exclusion of other issues, where previous tweets from Commissioner Makubela appeared to have a wider spread of interest. It then focused narrowly and specifically on Operation Dudula, Operation Dudula and its associated causes. As mentioned before, the use of social media to rally and garner support is not something to be discounted as simply being an online issue to not be brought into the real world. In fact, the use of social media to rally and garner support is a tool that Operation Dudula has become characterized by. The incitement to action, to dissemination of rhetoric, happens almost exclusively on social media. So a social media movement having an effect in real life is not something that is too far. It's not a bridge too far to expect that there's a reasonable idea of your views on social media and your views to this movement in real life are closely associated. Whilst we have no submissions about whether Commissioner Makubela may have participated beyond social media to amplify and add to the conversation in person, there was, in fact, an amplification of those ideas and views online. Commissioner Makubela is ostensibly someone who is engaged with current affairs and goings on of Operation Dudula. It is an organization that is reported in the media, and he continued to elect engagement with these accounts. And we take no issue with that. Having a view, whatever that view may be, however controversial it may be, is not the issue. But it is in the context of this commission, where the commission is so closely intertwined with the effect on foreign nationals, that this is not a mere factor that may or may not have an impact, but it's something that directly relates to the foreign nationals who form part of the first respondent. What is noted further is that that election to continue engaging did not seem to be an accident. Between the years cited, I think it was 2017 and 2022, the frequency cannot be denied. It was an area of frequent contact, both networking with other members of Operation Dudula via the interactions, as was set out in the submissions by my learned friend. And on the basis of that, there is a huge risk that the distress of the victims may impart a level of fear that will affect the findings of this commission. Commissioner Makubela's continued presence in the event that this application is not successful, and or if Commissioner Makubela does not elect to recuse himself, will result in a level of apprehension in the foreign nationals who are part of the first respondent, and the first respondent as a whole, for there are also South Africans who have been affected by Operation Dudula because of their proximity to foreign nationals. And this is in instances where a South African who was a resident of the building was in partnership or in a relationship with a foreign national, where they too were affected by Operation Dudula. Chair, I will now move on to the proper approach to recusal applications, and it does bear repetition in this instance, because what is central is not whether, as I said before, this commission in some ways in the decision-making process will be led by yourself, Lady Chair, or if there is a level of confusion or maybe not clarity in the rules as to how those decisions will come. But at the outset, that the process will be affected in a profound way. And the approach to recusal applications are as follows. That the approach must be objective, that the test for recusal is on the basis of a reasonably held apprehension of bias. In the context of the Commission of Inquiry, it is the following. The onus of establishing that the requirements for recusal have been met is on the applicants, that the facts relied upon, which are the true facts, must be correct, that the apprehension must be that of a reasonable, objective, and informed person, that it is a reasonable apprehension, and that the apprehension must be that the Commissioner will or will not bring an impartial mind to bear on the adjudication of the case, and that it is a mind open to the persuasion by the evidence submissions of counsel. We agree with and advance the proposition advanced by the applicants that the reasonableness of the apprehension must be assessed in light of the following considerations. That the purpose of this commission is to restore public confidence in the situation, in the way it is investigated, and further steps, as I understand, Part B is a larger inquiry as to other buildings in the city. It is also noted that Commissioner Makubela is not a judge and has therefore not taken an oath of office, as similar to be taken by judges to administer justice without fear or favor. He is not constrained by an oath of office in the same way as a judge would, and may very well infuse his performance of duties as a commissioner with elements of Operation Dudula to the prejudice of residents. To the best of our knowledge, he has no training or experience as a judge. This means that we cannot assume that he can disabuse his mind of any irrelevant personal beliefs or predispositions. And this is central. The purpose of the presumptions regarding to judges and the presumption against bias is because judges have training to disabuse themselves of their personal beliefs or predispositions. It is, however, noteworthy that judges of the High Court, in circumstances where it is relevant, will recuse themselves if there is any apprehension that the court may be brought down by a perception of bias. Additionally, and this is a practical measure, replacing Commissioner Makubela ought to be a straightforward process. There being more than enough persons who qualify for appointment as a replacement, and at this early stage of the proceedings, it would not inhibit the normal running of the commission. We respectfully submit that on the facts set out, the applicants have established the requirements for the recusal of Commissioner Makubela. It follows that there are several uncontested facts that we have relied upon. And I will lead this commission through the affidavit set out in support of the recusal. These affidavits comprise of residents, and it is by no means it's not a closed list, but these are members who specifically had personal experiences with Operation Dudula before and or after the fire. I can take the Commission through to the actual the supporting affidavit for the application of recusal by Hassan Ramadan. It is Annex A in the applicant's bundle,
What
but I think
page
that
number?
the page. My apologies. So the pagination I have may be different from the pagination that's before this.
How come is it different from ours? Why is it not consistent with ours?
I think that it was
Mrs. O'Brien?
simply because the bundle was made to include. I'm going to just seek an instruction. I will. 188. Mr. Ramadan is a Kenyan citizen who previously resided at the Usindiso building. He was, at the time of his affidavit, housed at the Hoffland Park Community Centre. That has since changed, given, as the Commission is aware, the urgent application relating to the removals of those residents who were at Hoffland Park. Mr. Ramadan holds the reasonably founded view that the findings of the Commission may be impacted in a manner that is not fair or impartial as a result of Commissioner Makubele's participation. Mr. Ramadan himself has been a victim of illegal raids, passport searches, and, an assault by members of Operation Dudula. Mr. Ramadan's partner is a South African woman who also was admonished in a similar way by members of Operation Dudula. If I may take the Commission to paragraph 10 of Mr. Ramadan's affidavit, he sets out that the circumstances of the raid, that members had come to his tuck shop, assaulted him, searched his person, and that they then looted items from his tuck shop. It then follows that in paragraph 11, that members of the building were gathered and forced outside as if to arrest those foreigners. There was violence, and Mr. Ramadan did thankfully escape anything further than his initial assault and losses. He then follows at paragraph 12 to state that on the morning of the fire, and I will read, on the morning of 31 August 2023, after Usindiso building had burnt and the flames had been extinguished, members of Operation Dudula arrived at Usindiso building, and I witnessed them arrive with shamboks and whips, singing Zulu songs in celebration that the building had burnt. I remember that the lyrics of the songs the members were singing, if translated to English, were, and I quote, "You kill our people, you hijack our buildings, you foreigners go back to your country," end quote. Members of Operation Dudula came back to Usindiso building on the evening of 31 August, they were marching around the building and singing the same songs as they had in the morning, while they could see that I was mourning the people that had passed away in the fire. I tried to speak to members of Operation Dudula as they were singing the songs to tell them that what they were doing was not right. But I was told, "You can't plan for us in our own country." I remember seeing at least 5 of the members wearing military clothing, whereas the rest of the members were wearing white clothing. Mr. Ramadan's testimony is one that is repeated in many of the affidavits submitted of these events where Operation Dudula had, on more than one occasion, attended the Usindiso building to implement their mob justice, mob violence, if you would have it. The next affidavit I will refer the Commission to is that of Thembinkosi Sithole, who is a South African citizen and a victim of the fire. This is at page 193 of the Commission's bundle. Mr. Sithole is, as I said before, a South African citizen. He recounts instances in May 2023 where members of Operation Dudula searched the building in an illegal search for drugs. He sets out that there were threats made by Operation Dudula members, and he also repeats the return on the day of the fire, that where Operation Dudula members celebrated the fire and threatened foreign nationals who remained near the premises. And I will read from paragraph 7 of Mr. Sitole's affidavit. Members of Operation Dudula came and knocked on my door and asked who I lived with. I told them I was living with my girlfriend and our son. At the time of the encounter with members of Operation Dudula, my girlfriend and son were not in the room. The members asked me where I'm from, and I told them that I was South African from Queenstown in the Eastern Cape. The members then informed me that they were searching for foreigners. The members then asked if I knew if drugs were being sold in the building, and I informed them that I did not know of any drugs being sold in the building. Paragraph 8. Two of the members insisted that they search my room. They did so without my permission. While searching my room, they unscrewed my compact disc jockey to check if there were drugs inside. They did not find anything. They exited my room and proceeded to the room next door whilst I stood at the door to my room. He then explains the treatment experienced by Tanzanians as he witnessed them, where at paragraph 9 it details an assault with a shambok of Mr. Sitole's neighbors, and members are threatening his neighbor, and it follows on in a similar fashion as had been previously. There is again a repetition at paragraph 12 that sets out the taunts of Operation Dudula, singing songs of celebration and stating their elation at the fact that the building had burnt down and that foreigners had died within it. At 13, notably, paragraph 13 states, members of Operation Dudula threatened that they should come back and find foreigners on the streets near the buildings. They will deal with the foreigners accordingly. Following on is the testimony of Ayubu Muiza, and I must just make a note before this court. That testimony it's at 198 of the bundle. There was a translator. Mr. Muiza does not speak English, and the manner in which these affidavits were collected is that the members who had been interviewed were made aware of the screenshots, and there may have been something lost in translation, and I must apologize to the Commission and to Commissioner Makubela. There are certain statements that attribute certain acts to Commissioner Makubela that may have just been an inaccuracy as a result of some such that was lost in translation. These are from paragraph 5 and 6 and 7, where in the translation, where the challenge of translation of the issues has been a challenge for the first respondent. It was done informally and not through. So while Mr. Musa may have a full testimony regarding Operation Dudula, there may have been a misunderstanding as to the extent of the statements of Commissioner Makubela. I will then direct the court to paragraph 9 of Mr. Musa's statement, where he sets out in June 2023 that there had been members of Operation Dudula who had attended Usindiso building and had threatened, harassed, and assaulted the residents. He continues to say that there has been general harassment by many parties to arrest undocumented foreigners without the presence of Home Affairs and migration officials, many having been arrested despite proper documentation, and he states that there had been bribes that had been elicited from foreign nationals over a period of time. Mr. Musa does conclude with the fact that at the time of this affidavit, he had been living at a shelter.
When you are adverting to the fact that there are inaccuracies in the affidavit of Mr. Muiza, are you also adverting to what appears at paragraph 6 of his affidavit?
Paragraph 6 of his affidavit.
Yes.
If I may say, I think that the confusion is in relation to paragraph 5, 6, and 7, where there may have just been something lost in translation as to the statements of Commissioner Makubela. It may be simply based on the impressions of the translated tweets and interpreting them as a verbal statement as opposed to a published statement. If I may continue.
Yes.
Chairperson, thank you. These, I will not go, I don't have to go through every affidavit because they do support a golden thread of the same occurrences. Before the fire, Operation Dudula conducted raids. After the fire, Operation Dudula persisted. It will, however, bear mentioning that the affidavits come from both South Africans and from foreign nationals, which may answer an earlier question as to the views of the larger base of the respondents and their views as to Operation Dudula. It seems to be that there is a consistent view on Operation Dudula in these supporting affidavits, as the effect has been harm suffered by the large portion as opposed to simply the targets. There was collateral damage in terms of the harassment faced by residents of the building. There is a level of sensitivity that is revealed in these affidavits to Operation Dudula, where there is a heightened level of sensitivity. The residents who have been victims or witnesses to victims at the hands of Operation Dudula are acutely aware of implications that may result from a possible member of Operation Dudula having a position on the Commission, where that member has previously expressed that government was not doing enough to address the issue of foreign nationals. The perspectives that are revealed in the supporting affidavits reveal a nexus of apprehensions, that they see their lived experience and the associations of Commissioner Makubela as set out in his Twitter account, that there is a meeting point that gives rise to a reasonable prospect of bias. The principle of impartial adjudication is not extended only to courts, but is extended as follows: that both criminal and civil cases, as well as quasi-judicial and administrative proceedings, require impartial adjudication. It has an application in this commission. That was in the South African Human Rights Commission on behalf of South African Jewish Board of Deputies v. Masuku at paragraphs 58 and 59. That is cited in my heads of argument. This application was not taken lightly by the respondents. The negative space of Commissioner Makubela's Twitter account is one where, in place of any other interest that may have filled such negative space, there is only reference to Operation Dudula almost exclusively. There is a very clear philosophical approach that he has adopted in his Twitter account that he published over a number of years. As a result, the residents, who are the first respondent, ask for the relief sought by the applicants be granted on the basis that the fear and the apprehension of this Commission's findings, however the machinations may be actually held or actioned, that apprehension in the hearts of the residents is firm and cannot be ignored per the case law that exists and per the principles that we must be guided on in this regard. Madam Chair, I have no further submissions unless there are questions.
Yes, there will be questions.
Yes.
There's no question for me.
Thank you, Chairman. Ms. Subrayan, I'm not sure if I heard you correctly.
It's Subroyan.
Subrayan.
Yes.
I beg your pardon. I'm not sure if I heard you correctly. Is it your submission that your members are saying, I am a member of Operation Dudula, or did I hear you incorrectly?
It's not incorrect when the membership of Operation Dudula appears to be something that is, as I said, an amorphous organization that mainly seeks its members and or supporters online, and your participation online does allude to the fact that you are in at least some way affiliated with Operation Dudula, either in support of or the dissemination of Operation Dudula's information via your retweets and or likes.
And your submission in relation to the inaccuracies of the statements, how did you determine that?
I have instructions as to the inaccuracy of the statement. When these proceedings were initiated, there was very short periods of time in which we had to prepare our papers. The translators for the statements were actually, I think it was Swahili for Mr. Muyiza, where another member who spoke English would translate for him in order to communicate the issues. What had happened in the process was, and it appears, there has been something lost in translation as to your statements on Twitter and versus what you've expressed. And I think it's not that it is inaccurate, it's that the perception was that you had stated things verbally as opposed to an analysis of your tweets.
On paragraph 6. Is it paragraph 6?
It is paragraph 6.
On paragraph 6. I have heard that he has stated that he is in support of Operation Dudula, who I believe were involved in starting the fire, but burned Usindiso building. Commissioner Makubela has, however, stated that he does not believe that Operation Dudula has any involvement in the incident. This is not true because members of Operation Dudula were present at Usindiso building on many occasions before the incident, together with members of the SAPS and the Johannesburg Metro Police harassing residents. You're saying this has been clarified to be correct or incorrect?
I've clarified that the Commission should discount that paragraph as it was clearly a misinterpretation or misunderstanding of the true facts. It is, however, consistent in the remainder of the supporting affidavits that there was an impression of your tweets and that there have been lived experiences of Operation Dudula. Paragraphs 5, 6, and 7 are anomalous in the remainder. So it's not that a fixed version of untrue events were given to all the respondents who completed affidavits. It's simply that one individual in the process of translation, which in the circumstances were difficult and informal, in order to ensure that this process was not lost in terms of delays, that there was something lost in translation. And my apologies are tendered on behalf of the fact that such translation was presented. But the remainder of the affidavit is unequivocal and is in line with all the other statements that have a consistent version. I don't know if that clarifies it.
No, what I want clarified is we should take the statements to the extent that you confirm their accuracy, and to the extent that you say they are inaccurate, we should then disregard that. Are these the only inaccuracies, or are there more?
I would submit that there aren't any other inaccuracies. The events recorded by the supporting affidavits are also confirmed by news reporting after the fire. It was reported that members of Operation Dudula had attended to the building and had engaged in a process of taunting, celebrating, and singing. My reason for specifically highlighting paragraphs 5 to 7 is because they do relate specifically to the issue at hand. If you read the wording, appears to be an expression of an opinion where that opinion may have been misinformed. The remainder is not an expression of opinion, but is a statement of fact of his witnessing Operation Dudula members come, and if I may state, but for paragraphs 5, 6, and 7, there is correlation in the events of descriptions of operations of members of Operation Dudula that is consistent throughout, both in the affidavits and in news reporting as to the actual facts of such events.
So who established the inaccuracies? Did you finally get somebody who was fluent in Swahili to talk to the gentleman after the signing of the affidavit? How did you establish this?
An actual analysis of it reveals, well, Commissioner Makabela, you yourself would be placed, you know what statements you've made or not made. There's clearly been, if you give regard to the wording of those paragraphs, there's clearly been something where they state regularly in this that they say you state X, Y, and Z. That is patently untrue. And if the Commission would want a further supplementary affidavit to correct those with a different translator, perhaps, that could be supplied. But on my feet, those are the submissions I can make as to the inaccuracies. But it does not affect, if you disregard the single affidavit of Ayubu Muiza, nothing else changes for the remainder of the applicants, of which I think there are six. There are 6 testimonies that have been put forward to this Commission in respect of your recusal.
And you're saying on the test that is applied, which is the reasonable and objective person, your clients, South Africans included, are of the view that there would be a bias insofar as the ruling is concerned relating to who started the fire.
It's not so, well, that inclusive. The larger purpose of the Commission is to make an inquiry into the causes of the fire, the circumstances before the fire, and the issues that related, the issues that affected residents in respect of the fire. Whatever those findings are, and we do not seek to preempt any finding made by this Commission, may very well be affected if there is a view that someone who espouses the xenophobic rhetoric of Operation Dudula has possibly an effect or impact on the state of mind and the impartiality of this Commission.
Part A of the Commission's work is to establish the cause of the fire and who has to be held accountable for it, if anyone at all. Now, you're saying the reasonable and objective person would actually, and these are the beliefs of your clients, that would think there would be a bias.
Confirmation bias is something that is observable in many forums.
I didn't finish
my apologies. My apologies. I misunderstood your pause for finishing your sentence.
Okay, go ahead.
As I said, confirmation bias is something that is known, that someone coming with a particular set of facts may have an influence, and they have not been trained to disabuse themselves of those notions.
And the bias would be an illegal foreigner started the fire.
Commissioner Makabela, by your own version, you have, as set out in the annexures of the application, made many references to your views on the crime rate and how it relates to foreigners. It is not a jump in logic to assume that that same thread of sincerely held beliefs, as was expressed by yourself in relation to crime, could not be extended to this Commission.
And the bias would be an illegal foreigner started the fire.
Would that not be an element of crime?
I'm asking in relation to the scope of work of the Commission, Ms. Subrayan, in relation to the scope of work of the Commission.
In relation to
the bias would be an illegal foreigner started the fire.
The Commission has not had a full view of all the testimony before it. We are of the view that there may be something that may give the Commission a suggestion or an inkling or evidence. We have not yet made those findings. The Commission, as I said, we cannot preempt. However, if we're speaking about apprehensions of bias as to the findings for liability, it may bear mentioning that, if I may just simply find it, your views as you set out, I think it was in relation, there was a tweet about prisoners in the ANC not doing enough. What conclusions could be drawn as to the bias that could be suffered by someone who has a level of confirmation bias where they perceive foreign nationals to be criminal agents and have criminal elements to them? And that view, however controversial or acceptable it may be, is your view which you are entitled to.
I'll ask you the same question I asked Mr. Brickhill.
Yes.
And I want you to clarify, well, I want you to hear your views on this. Do you hold the view that, and you have not made submissions in this regard, but I'm interested in hearing your views. Do you also hold a view that the decision in this matter must be made by one commissioner?
My instructions are that we did not make any supplementary affidavits, and that was simply due to the constraints that we had dealing with the urgent court order. However, if I may take an instruction briefly, Lady Chair.
Are you able to make submissions or not, Ms. Suprayi?
My submissions simply are that we are in support of series submissions as far as the decision-making process and the heads that was submitted. We did not make any official submissions on paper, and I would not be comfortable making those submissions on my feet.
Okay. There's no point in me asking you the other issues that I asked Mr. Brickhill. Thank you, Ms. Suprayi.
If I may make one further submission, simply in support of the question asked to Mr. Brickhill, Lady Chair.
In relation to what?
In relation to the letter and the propriety of the impropriety or proprietary of the letter. It appears that in the SAFU judgment, which is the locus classicus for issues of recusals, the court had actioned its judgment on the basis of a letter, and it does not seem to come from the case that there was anything improper by a letter setting out full reasons for the basis of recusal being handed to the judge, a judge who would be sitting on the bench with the other judges who had been accused of various biases, but a letter had been submitted, and it does not seem from the case law, if I may make that submission, that such is improper or is alien to the carrying out of the works, ethics, and duties of the legal profession.
Well, now that you stated that, let's go to the meeting then, because clearly you want to express an opinion on something that you have not made submissions on, but you want to express an opinion anyway. So let's go to the meeting then. Is it also your view that there was nothing irregular with a meeting being held with a person who ultimately is going to hear an application, and in that meeting discussions are held with regard to the contents of the application?
Commissioner Makabela, with respect, I would not impugn the dignity of the chairperson by suggesting that any meeting that she consented to and had been part of had any undesirable elements. I state again, it was simply to clarify a point of law in the judgment, the very judgment that I rely upon, that judgment related to a letter handed privately to a judge that then was canvassed in court by official application.
Nobody's impugning anybody's reputation, Ms. O'Brien. Nobody's impugning anybody's reputation.
Allegations of impropriety would suggest
You're interrupting me again. And in this case, I did not pause. You are interrupting me again.
My apologies.
Nobody's impugning anybody's reputation and dignity here. Nobody's doing that. I am simply asking you about the regularity or not of a meeting with a person who's going to decide on a matter and then discussing the details of that particular application in a meeting, wherein you've stated clearly that you would like for them to come alone. So nobody is impugning anybody's reputation. Nobody has said a discussion was held on how this matter must be decided. Nobody's saying that. I am simply asking you about the regularity thereof, whether you agree or not. So you're telling me about impugning integrity and everything else. I've never said that. I'm simply asking you about your views on whether or not this you regard as regular or irregular.
As far as it is expressing my views without making a formal submission from my client, it's regular that counsel will, or legal representatives can and have met with judges and chambers. The very urgent application which cited this commission had legal representatives have discussions with judges and chambers. So I cannot make any submissions as to the view that is perhaps sought by yourself.
Yes, but now, here's the question I'm asking you. Asking for a meeting and asking that a person comes alone and without the presence of the other legal representatives. Is that irregular? Is that regular to you?
Commissioner Makabela, the legal representatives of the first respondent were also not in that meeting, and we don't see it as an irregularity.
Yes, but it doesn't matter. The question I'm asking you is whether or not you deem it as irregular. If you say to me, no, I see nothing wrong with it, then so be it.
I see nothing wrong with it.
Okay, all right. No, thank you, Ms. Bryan.
Thank you, Mr. Bryan.
Thank you.
Advocate Minya.
Thank you, Chairperson and Commissioners. The calling for the recusal of Commissioner Makubela is uncontested. It's unopposed. There is nobody who's advancing an argument or a contention that suggests the relief sought in the application is ill-founded, unsupportable. No such conclusion has been made. So where does that put us? You can accept as a commission that this application provokes no legal controversy. The law on recusals is clear, it's tried. The highest court in the land has told us in more vivid terms how that matter gets approached. We have precedents for it, and there is no controversy provoked by the legal journey any decision maker must undertake in an application for a recusal. Now, the application is also predicated on a certain set of facts which have been deposed to under oath by various individuals who tell you that they are foreign nationals, that they are victims of the fire under investigation, and that there is an organization or organizations whose confluence of purpose is the same with that of Commissioner Makubele. They give you the facts, they give you the dates, they give you the places, they give you the vitriol that is in those tweets about foreign nationals. All of that is uncontested. There is no suggestion by anybody that they are mistaken, they are misconstrued, except what is said now, and I would have said I wish I had it under oath, but that's a different matter. As papers stand before you, there is no controversy on the facts. Now, on what basis in law can the relief that is being called for be resisted? Because, Chairperson, Commissioners, you must accept that to be true. Now, Commissioner Makubela has been alive to this application coming. He too has been alive to the facts underpinning the relief that is being sought. He elected not to contest the correctness of that, and in fact, in certain instances, we may even advance the argument that the allegations are irrefutable. The tweets are his. There's no ambiguity in the language. They're associated with Operation Dudula, and Dudula's purpose and views and put South Africa first are clear. There can therefore be no reason to say this decision, if this relief, if granted, will suffer lack of correct factual finding, whether there were any other counterfactuals or anything of the kind. No. It's clear. Now, if we accept the facts as we must, and we accept the law as pronounced by the highest court in the land, the conclusion is ineluctably that Commissioner Makubela must be recused. But why do we say so? Let's go look at the terms of reference and what it is that it seeks to address. It addresses the fire that was caused in Marshalltown Usindiso building. Please, Chairperson, Commissioners, take note that we are telling you about the evidence of those deceased in there, and we say to you, as of the date of 8 September 2023, among the dead were 21 Malawians. By any definition, they're foreign nationals. That's what Operation Dudula doesn't want. It is talking about those 21 Malawians who are living in the building. Operation Dudula, Put South Africa First, talks about 53 Tanzanians that were living there. It's not talking about anybody else. And one Zimbabwean. But painful, of all of those, 23 were children, foreign nationals, that Operation Dudula doesn't like, doesn't want South Africa to be part of. And then you tell their birth and their kin, you know what? This issue is going to be decided by Commissioner Makubela, whose xenophobia is as pronounced and unrefuted, and perhaps even irrefutable as we would want to suggest. And then the law says to us, no, but all you need to do is to ask an objective question. Would a reasonable person, properly informed, apprehend that there won't be a fair mind to be brought onto the adjudication of the issues? I would submit by every logic, by the smell of any rose, the conclusion is clear. They cannot harbor sufficient comfort that Commissioner Makubela will bring his unbiased mind to the subject. Now, we caution in the written submissions how one should approach the SARFU judgment. And it is important that Chairperson would recall, in the SARFU matter, the justices of the Constitutional Court made statements. Why? Because judges don't make affidavits. They don't swear under oath A or B. It is the office of judgeship, of judicial office, that carries that obligation with them wherever they go, whether it is even at a supermarket. They are expected by law to conduct themselves with probity, with propriety. Not Commissioner Makubela, who does not even want to favor us with a sworn statement, who is not telling us, even in an unsworn statement, that any of these allegations are untrue, or what he's being accused of impairing the confidence of the members of the public, and in particular those who are affected by the fire, stand to worry not. We were told a little earlier that circumstances change. I hope they do. But Advocate Makubela has not told us, even as we speak, that he doesn't hold those views attributable to him. He's quiet about it. And we make in the submission, Justice, that as an unopposed application, it stands to be granted. But let me go and discern exactly what it is that Commissioners Mabena and Makubela are enjoined by law to do. And I'll go to the terms of reference. In the proclamation, We have it, I think, under clause, well, not any particular clause, but if you go to the preamble where the Premier is saying, and therefore I, Andrek Panyaza Lusufi, Premier of the Province of Gauteng, hereby and in terms of Section 2.1 of the Act, read with Section 1272E of the Constitution, establish a commission of inquiry, the commission to, and it tells us what it is to be done, but over the page at subparagraph D, says appoint and designate Justice Sisi Virginia Khampepe as the member of the chairperson of the commission, as a member and chairperson of the commission. So we know exactly what it is you are to do, sitting there, chairperson, i.e. guide the conduct of this inquiry into a conclusion that makes factual findings and recommendation in relation to those for the advice of the executive. But it says, no, I want to assist you. And under E says, appoint and designate Advocate Tulani Makubela and Ms. Vuyelwa Matilda Mabena as additional members of the commission, and I want to emphasize what follows. To assist the chairperson. They have no other purpose to be in this commission outside assisting you in conducting the inquiry and in your work as a chairperson. And finally, in preparing the report of the commission. That is the ambit and the gambit within which their relevance is for this purpose of investigating the matters in the terms of reference. Now, this application provokes a particular element, which is a recusal, which we make the point it is quintessentially a legal point. You have to apply your mind on objective facts and look at those and come to the conclusion, would those facts applying the law bring home a conclusion that the apprehension is one that is reasonable, that there won't be a fair mind to bear on the facts, and maybe the conclusions that are drawn from it. So that is their purpose. Nothing more. And we make the submission that, therefore, ultimately what this reduces itself to is to say, you have had the application, is unopposed, you have had factual allegations under oath by members that have not been contested, they yield to the following conclusion and make the decision with the benefit of whatever assistance you may get from them. Now, Turnbull, subsequent to Sarfu, has also told us that's how the approach is had. But I must sound the alarm. We are not to entertain speculative hypotheses that have nothing to do with the papers that inform this application. They may provoke very nice debate and inquiry, but they're irrelevant in the approach the inquiry must take in relation to what are the facts. You have no other facts. There are no counterfactuals. The facts are as they are. And to reread what these victims of the fire are saying about it, that Operation Dudula was dancing, and somebody who is sympathetic to their cause, not only sentimental, but publicly expresses himself about joining cause with their purpose, surely must trigger in that witness statement a reasonable apprehension of fear and bias towards how the matter will be approached. And I don't think we need to make further submissions unless there are contestations and factual averments which are made to gainsay what is in the application. So far, there's none. And our submission finally is that this application is good on the facts, is good on law, and the conclusion is inevitable. There is no basis the conduct of this commission can go unhampered with the participation of somebody who holds such violent views about foreign nationals that are in the country. Those are the submissions we made. I can take questions.
Ms. Mapela? Mr. Mapela.
Yes. Thank you, Chairman. These hypotheses that you refer to, Mr. Sebing, that you don't want to have entertained, which makes for a nice argument and everything else. What are those? Exactly.
What conversations were held, where, and by who, and however. They're irrelevant.
Yes, I assumed so. The reason I assumed so is because you also see nothing wrong with that. Am I correct?
Even if I did, it's irrelevant.
Well, it is relevant, Mr. Simi, I'll tell you. And I'll tell you why it is relevant. It is relevant because, as you know it, any reasonable person, you included.
I don't like that slant, Chairperson.
But what is fundamentally wrong with that? Any reasonable person, you included.
I don't like that slant, Chairperson. I may be as unreasonable as they come. Don't assume anything
Mr.
in my
Mapela,
favor.
don't assume that he is included. Ask your questions pointedly.
Thank you, Justice. I was just making the assumption that he is. Now, any reasonable person, Mr. Simi, would have valid concerns with regard to applicants who intend to bring an application requesting a meeting with the would-be presiding officer and wanting to meet with her alone. Any reasonable person would have valid concerns, but you don't see those concerns. Am I correct?
I disagree with you profoundly. In the almost 40 years of legal practice, I always go to the chambers, even to introduce myself to the presiding officer and to enjoin the presiding officer with any matter incidental to the case I'm bringing. That happens regularly. If you shared my experience, you'd share my conclusion.
No, I don't share your experience because the reasons for going to introduce yourself before a matter is heard has got nothing to do with you going to the judge and saying, Judge, I intend to bring this application and these are the issues in this application. It's got nothing to do with that. Even in that 40 years that you're telling us about, there has been that has never been the intention. You go, you introduce yourself to the judge, and you go there together with your opponent.
Makes for great conversation.
Well, it does.
Commissioner Makhubela, but in my submission, final submission on the point, all those considerations are irrelevant whether there is any reasonable apprehension of bias in respect of a particular decision maker on a certain set of facts applying the law.
Well, I'll tell you why they are relevant. I'll tell you why they are relevant. They are relevant because you make submissions that in fact it should be the judge alone that actually makes the decision on this matter. That is why that discussion is very relevant. That is why that meeting is very relevant. Because you have a situation where a messenger was given a message to come call someone and to give a specific instruction that you must come alone. Instruction, that's my word. Come alone. And then you then go on to say, even if they did meet, even if we don't know what was discussed there, there is absolutely no way that a reasonable person will have concerns with regard to that. And then you go on further to say your submission is that alone the judge must be the one that actually makes the decision. That's the relevance of it.
All right. I wish, Chairperson, members of the Commission, we had that on affidavit, eh?
Yes, I'll come to the affidavits.
No, because you are placing before the Commission something nobody knows about.
Yes.
And I'm saying if you want to know about irregularity, that is an irregular approach. If you have things that you thought are relevant for the adjudication of this matter, you clearly would have, as a reasonable commissioner, place them before the parties.
Yeah, and that's exactly where I'm going to. That is the procedure that you actually outline. That, in fact, a recusal application should not be heard by the person against whom it is brought. Am I correct in the summation?
You're so wrong.
Yes, that's why I'm asking if I'm correct.
No, you're wrong.
Yes. What is the difference then with regard to this particular recusal application?
One, you're not a
but
judge.
I'm not done.
Oh, sorry.
Please go ahead then. No, please go ahead.
You're not a judge. You have not taken oath. You have no judicial training. You have not given us a statement. You have not given us a statement under oath. So I can't take what you say at face value.
Yeah. As a result, we then have to come up with our own procedures. Those procedures are file your notice of intention to oppose an affidavit and appear before the very panel with whom you are members of the commission.
Another hypothesis. What are the facts to that?
You've made submissions, Mr. Smee.
Yeah.
In your submissions in relation to how this matter must be decided.
I agree.
You've made submissions that, in fact, and you've cited the terms of reference, and I think even, I'm not sure if the rules are cited. And the conclusion is that it must be decided by the judge alone because the other members are just assisting.
I do.
So why is it a hypothesis? Because then you've made submissions to this regard. You've made submissions to this regard. You've said it must be decided by the judge alone. Now, here's another thing that I would like you to clarify me on. What is the basis? Okay, what is your role as the evidence leader?
I can read it to you.
Yes, please, if you can.
Let's go to the terms of reference. I think it is clause 4. No, it's actually schedule part A at clause 3 to the proclamation. The commission may choose and appoint one advocate who is a registered member of the Legal Practice Council of South Africa to act as counsel. That's the first thing I'm doing here, to the commission. To assist in the inquiry, that is what we are doing here as evidence leader. Advise on matters of law, that is what my submissions are, and advise on matters of evidence, and present evidence to the commission at its inquiry. Those are my responsibilities as given by the proclamation, Commissioner.
And who are you representing in these proceedings now?
I'm representing nobody, but again, Commissioner, with respect, those questions and inquiries and interrogatories have absolutely not anything to do with whether...
They do.
Can I finish now?
Well, they do.
Can I finish?
Go ahead.
All right. They have absolutely nothing to do with whether a reasonable person applying their mind on proper facts informed would come to the conclusion that you are capable of bearing a fair mind in the adjudication of issues that will serve before the commission. That's what the law tells me.
Well, they do. They all do. You are firstly acting outside the scope of your appointment as the evidence leader. You say you've read from the terms of reference what the evidence leader is actually supposed to do is is it part of those terms of reference is what you are currently doing and the submissions that you've made in this application? And I don't know again who you're actually representing. Part of the counsel that you read from the terms of reference, which is part of the scope of your appointment.
I did not hear any question. You are just expressing yourself.
I'm asking a question, is that part of it?
But I've just read them to you. You say I'm not, but you're not telling me what finds the basis for your opinion.
Okay. So you are a party to these proceedings here, not representing anybody.
Commission.
And in fact, if I were to take your understanding of the terms of reference in relation to you giving counsel to the commission, would that then mean you are representing the commission in your submissions?
Chairperson, as a matter of law, commissions are investigative platforms which the executive in a constitutional democracy triggers on issues of public interest. It has no parties to it. It has no orders to it. It has no functions and powers that reside in a judicial officer. None whatsoever. It's investigative. To call me representing a party is just an unfortunate description of my role.
So there are no parties to this application. Question.
I reiterate my answer. Commissions of inquiry are not courts of law. There are no parties. There's no misjoiner. There's no non-joiner. The rules of evidence don't apply strictly. The commission conducts its investigation in a manner best fitting to it.
Now, is that the same notion? Firstly, let me ask it this way. What informs and what authority informs the fact that a person against whom a recusal is brought, or is it because they are not a judge? And I'll allow you to answer it, that they need to file a notice of intention to oppose and oppose the application. What informs that? What's the authority for it?
Because a commission would not consider facts that are not under oath. And if this relief was going to be opposed, you would expect whoever wanted to oppose it, even Operation Dudula, if it was so minded, you would expect them to file a notice to oppose.
Well, they wouldn't have, because they were not cited and served.
No, don't interrupt me too. I'm showing the courtesy that you demand it be shown to you, and I intend to abide by that. I'm saying there are no rights affected by a commission. There are no interests affected by a commission. What a commission does in law is to garner the facts around that matter of public interest, and having garnered them, to take them to the executive and say, our investigations has revealed this litany of facts. And based on them and the questions in the terms of reference, we as a commission are giving advice and recommendation to the executive to implement that if we were to avoid a recurrence of something so ugly that has provoked such public interest. That's what a commission is.
It does not apply any well-founded procedures in law. It does not apply precedents, or am I incorrect?
I've got witnesses, Commissioner, I have never said anything of the kind. And
Yes,
if I
but
intended
it's
to...
a question.
No, there are innuendos in your questions, Commissioner. Please, I would like us to engage intellectually, honestly on the subject. I'm making no innuendos about you at all.
Similarly, Mr. Smith, I'm making no innuendos. I'm simply asking a question which I would like you to assist me with an answer to. I'm making no...
The answer is no.
innuendos. It would then be correct if that is the case, Mr. Seming, for one against whom an application is brought. Oh, sorry, your answer was no, so it does not follow any procedures. And am I hearing you correctly?
Are you asking if the Commission can make its own procedures and rules?
No. I'm asking if it should follow precedents.
Good precedents, it should. It should follow the law, it should follow the practice, and it should rely on facts placed before it properly and make as best an attempt of applying the law to the facts and come to an outcome.
And because commissioners haven't been trained like judges, and they haven't taken a similar oath, they then, in the event of a recusal, should actually oppose and file affidavits. And that's the only basis on which we're saying that's the procedure we should have followed.
I don't want to misunderstand you. Can you repeat your question?
The reason we are not following the normal recusal procedures in this particular case, or we intended not to, is because commissioners, unlike judges, have not taken the oath, are not trained as judges are, and as a result, it would be prudent that if an application for recusal is brought, it needs to be opposed, and there needs to be affidavits to that effect.
Commissioner, your question assumes a fact not in evidence. You are already assuming by that question that you are not taking a normal procedure.
Okay.
In what respect you are not disclosing? I'm unable to answer your question.
Well, I have established that basis, Mr. Semenya. I've asked you, you have said in your submission, there is no affidavit, this matter is not opposed, and therefore the facts are not challenged or disputed. It presupposes, correct me if I'm wrong, it presupposes that it should have been opposed. And it also presupposes that there should have been papers filed.
No, it doesn't at all. In fact, the notice says, if so minded to oppose, if so minded to file an answering affidavit, do that. You have elected not to. So I don't understand another hypothesis. It's a matter of fact that you filed nothing.
It is. The last questions, one or two, Mr. Semenya.
Yes.
Your understanding of the other two members of the commission, you've read from the terms of reference. Your understanding of the other two members is that they just are there to assist. Can you just clarify for me, they are there to assist on?
The inquiry. I can read it back to you.
Yes. And the opening statement that you've read from that proclamation by the Premier says Justice Khampepe as a member, and then the other members. You are saying, though, that the other members' status is not equivalent to that of the chairperson, other than the fact that he or she is the chairperson.
Again, not out of my mouth. One of the inquiries, what caused the fire? I see additional members throwing their weight in the weight of evidence to discern who did that. That is assisting the chairperson.
But the final decision is that of the chairperson.
There's no final decision in a commission, chairperson. The commission is there to investigate facts and to make recommendations. There's no final decision.
But those recommendations, who should they be coming from?
From the chairperson with the assistance of the additional members.
Or do they play a role in the final report, in the final recommendations, according to you?
It even says in the final report the additional members are to assist the chairperson.
In relation to, sorry, I interrupted you.
That's all right.
You can continue. In relation to the decision making with regard to the recusal, what is your position?
The position is one that is a legal question requiring legal understanding, legal application of the law, judicial training that this chairperson possesses and other members don't. But she can benefit from any assistance they would want to offer or she would want to obtain from them so that she makes the decision.
Okay. Thank you, Chair.
Thank you, Advocate Minya. Mr. Brickhill.
Chairperson, no submissions in reply or response.
In reply. Thank you very much. This commission has heard the submissions made by the parties in this matter. The ruling of this commission is reserved. The commission adjourns.
Good idea. It might be someone.